The Honorable the Chief Justice and the Associate Justices of the Supreme Court of the United States, oyez, oyez, oyez. All persons having business before the Honorable Supreme Court of the United States are admonished to draw near and give their attention, for the Court is now sitting. God save the United States and His Honorable Court.
Good morning. This is the case, Texas v. Smith. Other counsel ready to proceed?
Yes.
I am Chief Justice Munguia, and I would like to introduce the other members of the court. Chief Justice Ian Flores, Justice Morales, Justice Tabareza, and Justice Ray. Counsel for petitioner, the state of Texas. Are you ready to proceed?
Yes. My name is Brandon Noren, and I'm counsel for petitioner. I'm Mr. Broussard, counsel for petitioner.
Ms. Silva, counsel for respondent.
Ms. Rudillo, counsel for respondent.
Anthony Serafine, counsel for respondent.
Good morning, Chief Justice Munguia, Associate Justices. My name is Lars Broussard, and I'm here for counsel for petitioner on behalf of Texas. I'm here to urge you to reverse the decision of Texas v. Smith based on the case precedent of Terry v. Ohio. In the case of Terry v. Ohio, the precedent is police may stop and frisk if there is reasonable suspicion, and that suspicion must be based on observable fact or articulable facts. Mr. Smith was standing on a sidewalk when the police showed up. Once they showed up, he fled. By him fleeing, that creates reasonable suspicion to chase after him and frisk him. The fact that he was in a high crime area furthers the fact that it was reasonable suspicion to chase him down. Yes, in the case of Alberti versus the United States, it says that people can flee out of fear of humiliation. However, say if a person was to see Mr. Smith fleeing in that high crime area, he would think that he had done something illegal or was about to do something illegal. Now, replace that innocent bystander that sees Mr. Smith with a police officer. That creates even more of reasonable suspicion for the police officer to chase after him, because a police officer is the officer of the law. He is there to protect both himself and the other people around him and his environment.
Do you suggest we make a law that all people fleeing from the scene of high crime areas should be stopped and frisked for suspicion?
I'm not saying that. But I'm saying with that, innocent people may be stopped. But however, it's for the safety of the civilians around him, and it takes 2 minutes out of their entire day.
So you're suggesting you favor the status quo?
Can you explain what that means?
But that's like how it is right now, like.
So I don't know what the status quo is. I mean, you can't ask me questions I don't know.
Oh, is it still rolling? Okay, never mind.
Are there any questions? Counsel for respondent. Are you ready for Mr. Smith?
Good morning, Chief Justice Munguia, Associate Justices. My name is Ms. Silva, and I'm counsel for respondent. On behalf of Mr. Smith, I am here to urge you to drop the charges based on the case proceeding with Terry v. Ohio. And based on Terry v. Ohio, police can stop a person when they have a reasonable suspicion supported by articulable facts that a person is engaged or about to engage in legal activity. The police searched the subject with the articulable facts that Smith was engaging in the legal activity. Smith was only standing and only fled. However, it is not enough to search Smith. The police must also have suspicion that one is armed, though they did not have suspicion nor facts that he was armed. Therefore, the gun shouldn't be allowed in the case, considering he was searched unreasonably. Whether it was a high crime area or a low crime area, running away from the police isn't enough to charge someone.
Any questions? Counsel for petitioner, your rebuttal.
my opponent has said that there were no articulable facts stating that the search was justified. However, I do have some. Fleeing, high crime area, and also the speed at which someone flees are all articulable facts. Another thing is that for the safety of those around in the neighborhood surrounding, as my partner has said, taking 2 minutes out of somebody's day for a search will not kill them or make them late for anything. And if they were late for something important, they have a justified reason. Now, if that person had nothing on them at all, then there's no problem. However, searching people is good because you once in a while you will come across somebody who does have something or evidence or something that has taken place. And
But here in Arbitrary versus United States, 1896, it states that the innocent turned scientists flee the police because they were scared of being accused of crimes they didn't commit or out of fear of humiliation. What do you have to justify for that? What if he was fleeing the scene just out of fear of humiliation?
And also, what if you had the gun for protection?
In a high crime area.
then it should have been registered.
What?
Do we have facts that it wasn't registered?
We don't have facts that it was either.
Then you can't argue.
Then the question was... What was your question again, sir?
What do you have to justify Arbitrary versus United States?
About how he might have been fleeing out of
innocent-
humiliation.
Exactly.
If
From
he-
being accused for a crime he didn't commit.
Well, we have no facts saying that a crime was committed within the area. So I do not believe he could have been fleeing from a crime, therefore there should have been no accusation or humiliation. And even if he did feel humiliated at the fact he was being searched,
Also in Brown versus Texas, 1979, ruled that people have the right to refuse police contact and go on their own way. Are you justifying that we should make a law that there should be a significant speed people should leave their own way?
I would say a law should not be made for it. However, when you're sprinting at your fullest away from the police, that has reason for suspicion.
What is sprinting?
Sprinting is running at your maximum speed, which you can only last for about 5 minutes, which soon you run out of breath and makes you lightheaded. That is what sprinting is.
Okay, so how do you know that he was sprinting? Did you measure how much? How do you know how fast he can run? Well, how do you know his limit of how fast he can run?
I do not know how fast he can run. However, usually fleeing is synonymous to the word sprinting when running away, and especially from the police. Usually nobody jogs.
That doesn't
And
matter.
the court also did not say how quickly or slowly the person had to walk.
A question was brought up saying, should we make a law of how fast somebody could run? I'm saying no. But if he did, keyword if, then that would make a more
These
justifiable
are facts.
Yeah.
There's no ifs.
So there's also no fact of how fast he was fleeing, so why was that question brought up? I'm questioning myself now. That is all.
We will now enjoy and make our decision.
All rise.
Good afternoon. Majority of the room. Justice Reyes.
Good afternoon. Thank you, counsel, for your articulate and intelligent arguments. At this time, we are ready to render our decision in the case of Texas versus Smith. It is the decision of the majority of this court that the decision below is affirmed. Under Terry versus Ohio, police can conduct a stop and frisk if they have articulable facts to support a reasonable suspicion that a crime has been or is about to be committed. The facts of this case are a 44-year-old Latino fleed from a sidewalk. When a police officer showed up, they frisked him and found the gun. We find that Smith fleeing the scene in a high crime area is not an articulable fact to support reasonable suspicion by the police to stop and frisk. In Alberti versus the United States in 1896, the innocent sometimes flee the police because they are scared of being accused of a crime or out of fear of humiliation. In Florida versus Boyer in 1983, people have the right to refuse police contact and go their own way. The court did not have to say how quickly or slowly the person had to walk. Thank you for your time and attention.
All rise. Justice and the Associate Justices of the Supreme Court of the United States. Oyez, oyez, oyez. All persons having business before the Honorable Supreme Court of the United States are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court.
Good morning. This is the case of Texas v. Smith. Are counsel ready to proceed?
Yes.
I am Chief Justice Hamilton, and I would like to introduce the other members of the court. This is Justice Asensio, Justice Tarrant, Justice Palacios, and Justice Santos. Counsel for petitioner, the state of Texas. Are you ready to proceed?
All right, Mr. Arribi-Wasco, counsel for petitioner.
Ms. Bushinova, counsel for petitioner.
Mr. Sevilla, counsel for petitioner.
Mr. Morales, counsel for respondent.
Ms. Counsel, counsel for respondent.
Good morning, Chief Justice Hamilton, Associate Justices. My name is Marlon Sevilla, and today I am counsel for petitioner. On behalf of Texas, I am here to urge you to reverse the holding of Texas versus Smith based on the precedent of Terry versus Ohio. The area the suspect was in was a high crime area. This was ruled by the Texas Supreme Court. Referring back to the Terry versus Ohio case that this case is being based on, the Supreme Court ruled that the police have the right to conduct warrantless stops and searches to protect themselves and bystanders from those who may potentially be carrying concealed weapons.
Do you believe that anyone in the high crime area should be stopped and frisked?
Yes. The Supreme Court inferred that
Would that not be a violation of the Fourth Amendment?
potentially, but again, referring to the fact that officers have their own duty to fulfill in the high crime area, it makes sense that officers should be able to stop those who act suspiciously. The Supreme Court inferred that the police do not need probable cause to stop a person, only a reasonable suspicion that an illegal activity is taking or about to take place.
A high crime area is an articulable fact for this trial?
No, I do not believe that matters, primarily because it doesn't matter whether you're in a high crime area or a low crime area. You could be in Walmart or you could be in this zero situation. It does not matter. The simple fact is an officer has a duty to fulfill, and in this situation, whether it is, again, in a low or a high crime area, if a person acts suspiciously and can do harm potentially to others or is involved with an illegal activity, it makes sense. An officer should be able to fulfill his duty.
So are you suggesting that this would be his fleeing? That is what you suggest gave the officer probable cause to search him?
In a high crime situation, it makes sense because a veteran officer, Timothy Nolan, has the reasonable suspicion to investigate a situation that this suspect is in.
Counsel, didn't you just say that the high crime area was not the reason for the reasonable suspicion?
for the situation, I do believe this mattered. But in a standard and general situation, I do not believe that it should matter where the situation is. By sole fact, the suspect fled in this situation. He fled, and therefore the officer had a suspicion to investigate. It did not matter whether it was the high crime or not in a general situation.
Okay, so for clarification, it was his fleeing the scene
Yes.
that created the, okay. Thank you. Any other questions? Questions, Justices?
I do. Why would Smith's actions provoke such a large police response?
I'm sorry, can you repeat the question?
Why would Smith's fleeing provoke such a large police response?
The question itself can be a bit ambiguous, but I do have to say that referring to the fact that this again has been ruled as a high crime area filled with violence, has to be defined by a high crime area, the simple fact that 4 police cars filled with 2 officers each converging on a single position should not count into a fact of fear, primarily because in a high crime area it makes sense that such large amount of force is necessary to maintain balance and safety within a community that desperately needs it.
Okay, so then the high crime area would be a factor in this investigation, not simply just his fleeing the scene.
Yes.
Counsel for respondent, Mr. Smith, are you ready for the argument?
Yep. Good morning, Chief Justice Hamilton, Associate Justices. My name is Martin Morales, and I am counsel for respondent. On behalf of Sam Smith, I am here to urge you to uphold the ruling below based on the precedent of Terry versus Ohio. Now, as the counsel for petitioner said, this was involved with the high crime area, but he's been contradicting himself the whole time between switching back and forth whether you can believe if you can consider the fact of the high crime area is a part of this search or not. Now, in Terry versus Ohio, police may stop and frisk if there is a reasonable suspicion. That suspicion must be based on observable, objective facts, which is articulable facts, and they can't act as a hunch. The gun that they found on Smith was not seen. It was under him. And also, one of the things about the whole Terry versus Ohio case was that some people flee because of humiliation.
Should we consider how fast Smith fled the scene?
No, because it can go both ways. So that's kind of like a dead fact.
Should we consider any other factors other than Smith's location that would indicate unlawful activity was taking or about to take place?
No, because he was just standing on a corner and at the site, it's all humiliation. And if I was him, I would not run, but still, I can understand why. Because also, psychologically, they have this part in their brain that's either fight or flight. So in this case, his flight was more stronger than his fight. So just to stay still and while at the side of the police.
Thank you, counsel. Any other questions? Your rebuttal.
Ms. Bougenko, counsel for petitioner. I would like to say that the community was considered to be a high crime community. Therefore, more police cars were necessary to maintain a higher control of and maintain the balance of the community. The right to refuse police contact, yes, people do have that right. However, the person, when seeing the police officers, fled the scene. This shows suspicion because the person would not flee if they weren't guilty of something. Police are there to protect the people, to protect themselves and to protect the community. Why would a person flee the scene when seeing a police officer if they are not about to commit a potential crime?
With all due respect to counsel, they can flee for fear of humiliation or fear of being accused of crime they did not commit.
Yes, they can, but wouldn't that be suspicious? It would be, because the police are there to protect the people. They're there to help them. They're not there to humiliate them and to scare them away. Therefore, they should be able to have checks and to see what's going on in the case.
So would you please summarize why you think that it is justifiable that the police stopped and frisked Mr. Smith?
I believe that Mr. Smith was supposed to stop and check because he fled the scene when seeing the police officers approaching him. The area was considered to be a high crime area. Therefore, it has a higher possibilities of crimes happening And therefore, more police cars are supposed to be around and to maintain the balance and control of the area and to make sure that the community is safe. Thank you.
Any other questions, council? Okay, thank you. We will now adjourn and make our decision.
All rise.
Good afternoon. Thank you, council, for your articulate and intelligent arguments. At this time, we are ready to render our decision in the case of Texas v. Smith. In the decision of the unanimous majority of this court, the decision below is affirmed. Under Terry v. Ohio, police can conduct a stop and frisk if they have articulable facts to support a reasonable suspicion that a crime has been or is about to be committed. The facts of this case are: Smith exited the scene when 4 police cars appeared, and the police chased, stopped, and frisked him. We find that leaving a suspected high crime location are not articulable facts to support reasonable suspicion by the police to stop and frisk Mr. Smith. This is because Smith can refuse to speak to the police as well as exit a scene where police officers are located without being subject to a stop and frisk. Thank you for your time and attention.
All rise. All rise. The Honorable, the Chief Justice and the Associate Justices of the Supreme Court of the United States, oyez, oyez, oyez. All persons having business before the Honorable, the Supreme Court of the United States are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court.
Good morning. This is the case of Texas v. Smith. Are the council ready to proceed?
Yes.
Yes.
I am Chief Justice Zuniga, and I would like to introduce the other members of the court. We have Justice Lopez, Justice Kukushla-Patkin, Justice Zavala, and Justice Tesoro. Counsel for petitioner, are you ready to proceed?
Yes.
Ms. Ramos, counsel for petitioner.
Mr. Gray, counsel for petitioner.
Mr. Linares, counsel for petitioner.
Ms. Cienfuegos, counsel for respondent.
Mr. Pagan, counsel for respondent.
Good morning, Chief Justice Zuniga, Associate Justices. My name is Marlon Linares, and I'm counsel for petitioner. On behalf of Texas, I am here to implore you to reverse the decision of Smith versus Texas based on the case precedent of Terry versus Ohio. Some of the facts we know about Texas versus Smith is, 1, he fled the scene as soon as he encountered police. There's 2 police cars with 8 officers in them total, and he was in a high crime area.
Are you implying that anybody who seems to be running away from the police should be stopped and frisked?
No, I do not. But the fact that he was in a high crime area raised reasonable suspicion that he was either committing a crime or was going to commit a crime. So,
Can you
as a
explain the suspicion to me?
well, the fact that he was in a high crime area already raised enough suspicion because police activity is mostly high in that area. So the fact that he fled as soon as he encountered police raised suspicion, as he may have been committing a crime
or about to commit a crime.
The policy of opposing has a substantial risk of law into people being arrested with false cause, correct?
Yes. And the precedent of Terry versus Ohio is that people may, it's that police may conduct warrantless searches due to the fact that suspicion may be enough for them to conduct so. And the Supreme
So
Court.
is your only suspicion argument that it was a high crime area?
No, it is not.
What's your other argument?
The fact that he ran away from police.
And what exact speed must running away be defined?
Well, as shown in Alberti versus the United States, people may flee from the police due to fear of humiliation. But people may just choose not to encounter police. They simply have the choice of walking away.
So are you saying that if the same situation occurred in a low crime area, the police wouldn't chase the suspect if he
No.
was running?
Yes, if the person was running, they may actually stop them and search them because just
Are
running
you
away.
sure about that?
Yes. Running away from the police is enough suspicion for them to stop and search. That is all.
Are there any questions? No? Counsel for respondent, Mr. Smith, are you ready with your argument?
Yes. Good morning, Chief Justice Zuniga, Associate Justices. My name is Kimberly Cienfuegos, and I'm counsel for respondent. On behalf of Sam Smith, I'm here to urge you to uphold the ruling of Texas versus Smith. As human beings, our brains are of vital importance to us. And if we refer back to the subject of psychology, the amygdala is what activates the fight or flight response. And in this case, my client just happened to have a more developed flight response. He fled due to the fear of humiliation or being wrongfully convicted for a crime he did not commit. This is all in accordance with the ruling of Alberti versus United States.
So restating what you said, a suspect may flee due to fear of humiliation or false accusation. So are you suggesting that fleeing is not an articulable fact?
Yes, it is not an articulable fact.
Then what would be a reasonable cause to stop and frisk a man?
I am not a police officer, therefore I cannot solidify what an articulable fact is. I can merely suggest it. Fleeing is not an articulable fact. A scream for help or something that in actuality indicates that a crime is occurring or will occur is an articulable fact.
So you're saying that the police had no evidence whatsoever to stop Mr. Smith?
No, they did not. We have to consider 4 patrol cars, each containing 2 officers, 8 officers in total, 4 patrol cars. This would be a sight of fright for anyone, which would result in fleeing, which is not an articulable fact the police can utilize to stop and frisk someone. Thank you for your time.
Good morning, Chief of Justice Zuniga, Associate Justice. My name is Joel Pagan, and I am counsel for respondent. Petitioners would have this court give reasonable suspicion under Terry to anyone living in a high crime area. It is unjust to associate a high crime area with suspicion because some people are forced to live in these areas.
Counsel for respondent, high crime areas are considered high crime areas for a reason. Why shouldn't the police be on high alert for suspicious activity?
It is a discrimination to allow police to stop a person that is avoiding contact with the police and lives in a high crime area, because the same rule wouldn't apply to someone living in a low crime area. People that live in a high crime area are usually forced to live there because of their low economic status.
So are you saying that this is more of a racial bias view based on the community which the individual happened to be?
Not necessarily, because the same as a Latino man would be have a low economic status, a white male would be the same. Saying that anyone who avoids contact with the police in a high crime area should be stopped would be considering violating their rights as a person. That is all.
Thank you. Are there any questions? Counsel for petitioner, your rebuttal.
Good morning, I'm Mr. Gray. What the counsel for representative said, that fight or flight is in all of us. But what caused Mr. Smith to be so scared? The police are there to protect the people from any and all dangers.
Do you know why he was scared?
I do not know. But I do know that Mr. Smith was committing a crime. He was carrying a concealed weapon, and
were the officers aware of this?
no, they were not.
So what justifies them chasing him? besides the fact that he simply might have been trying to avoid any police contact, as it is his right.
Mr. Smith was doing nothing at the current moment in time. As soon as he saw the police coming, he was scared that he was going to get caught for the crime that he was
Is
committing.
it possible that he has a phobia?
There is a possible, and we do have the right to walk away from the police. But instead of walking away, Mr. Smith ran away from at the sight of the police. He wasn't running away. He wasn't jogging as in the morning. He was running away at the sight of the police officers. And the high crime area.
Many people have different ways of showing and demonstrating their phobias. Do you think that perhaps running away was his first instinct?
I do believe it was his first instinct, but it was the wrong instinct since it was reasonable suspicion for the officers. The officer that gave chase was a veteran officer, so he knew the streets and he has been around, so he knows what's suspicious and what's a false positive. A high crime area was ruled by the court, and a high crime area is defined as drugs and weapons are commonly carried by persons in this area.
So are you trying to say that every individual living in that community is considered a suspect?
No, I do not. But there's a higher suspicion that most people are carrying drugs and weapons commonly.
Really?
Weapons can sometimes be carried, especially in a high crime area, for self-defense.
That is very true. But Mr. Smith had no permit and was carrying concealedly.
Did you know that at the moment?
I did not know that at the moment, Your Honors.
Are there any other factors?
The four the four police cars. That has to be to maintain the order in a high crime area. Even though it is a high crime area, running away from the police in a low crime area is still reasonable suspicion for the officers, whether it's a low crime or a high crime. Running away at the side of police.
Do you believe that seeing a certain amount of patrol cars could install fear into the community, into innocent bystanders, according which Mr. Smith could have been?
Police officers are there to protect people from any and all dangers.
Do you believe that all people in that residency feel that way? Do you believe that they could have past experiences which make them feel otherwise?
I do believe that there are crooked cops, that there are crooked people in the justice system, and teachers, and everything, in every day of life. People are afraid, but people with past experience should try to get over them because police are there to protect. They're always bad apples, but majority of them are there to protect people. It's their job.
Well, it is true that we need the protection, but do you think that just having four police cars with two each, which makes it 8 policemen, does that seem far enough? Like a bit too much?
It could have been sheer coincidence. The 4 police cars were there at the exact moment in time. They could be on patrol and just converged on one point. That is what the police do. They manage and patrol an area as a group so they can stay safe and also to maintain a watch in the area.
So isn't it reasonable for an innocent person to want to get away from that area? Especially maybe there could be another crime happening at that time and the person just wanted to get away.
That is very true. We do have the right to walk away and...
What if the individual believed that something could have been happening? What if he was trying to get away from any sort of problems that could have occurred by seeing so many policemen in a quote-unquote high designated crime area?
The police officers did not know if there was a crime committing, but if they did, they had reasonable suspicion that Mr. Smith was the suspect that committed the crime that quote-unquote was committing around Mr. Smith.
So anybody that runs away from the police is considered a suspect?
It's very reasonable suspicion to stop the person and to wonder why they're running away. That is all.
Any questions? We will now adjourn and make our decision.
All rise.
Good afternoon. Thank you, counsel, for your articulate and intelligent arguments. At this time, we are ready to render our decision in the case of Texas v. Smith. It is the decision of the majority of this court that the decision below is affirmed or reversed.
Which one?
We believe that it is reversed.
Reverse?
Affirm, my bad.
Affirm, thank you.
Under Terry versus Ohio, police can conduct a stop and frisk if they have articulable facts to support the reasonable suspicion that a crime has been or is about to be committed. The facts of this case are the fleeing of Mr. Smith in the sight of 4 police cars in a high crime area. We find that fleeing in a high crime area are not articulable facts to support reasonable suspicion by the police to stop and frisk Mr. Smith. Albert versus United States case states that innocent people may flee at the sight of police presence due to fear of humiliation and false accusation of a crime being committed. Thank you for your time and attention.
All rise.